She was standing on her own porch holding a broken key when they slammed her face into her own door. They thought she was a trespasser. She was the federal judge who had personally signed their department's wiretap authorizations 4 hours earlier. Their careers ended before the handcuffs clicked shut. They just didn't know it yet. The red and blue lights fractured the silence of Maplewood Estates with the violence of something that did not belong there. A woman in a tailored trench coat was shoved hard against a heavy mahogany door, the cold steel of handcuffs biting into her wrists. She was not a prowler. She was not a criminal. She was the Honorable Renee Washington, a sitting United States federal judge, and the two officers slamming her into her own front door had no idea they had just assaulted the exact magistrate whose signature authorized every wiretap their precinct had relied on for the past 2 years. The trap was already closing. They were already inside it. They would spend the rest of the night building the walls higher. The neighborhood of Maplewood Estates announced itself in the ways that old money always does, not loudly, not with fountains or gilded gates, but in the weight of silence after 10 o'clock, in the width of the lots. In the amber warmth of streetlights that cast the manicured lawns in a glow that managed to feel simultaneously welcoming and exclusive. The oaks lining Halcyon Drive had been standing since before the Civil Rights Act was law, and on winter nights the wind moved through them with a sound that was almost musical, almost a warning. It was 11:47 on a Wednesday in early February when Judge Renee Washington turned her dark blue sedan onto Halcyon Drive and felt the specific physical relief of being almost home. Not emotional relief, something more fundamental than that. A loosening in the shoulders, a slow exhale. The unconscious unclenching of a jaw that had been set hard for the better part of 14 hours. The heater was running at full blast, but the cold had gotten into the car somewhere around the interstate exchange and refused to leave the way February cold, in this part of the country, always refused to leave, following you indoors and into the bones. She pulled into her long driveway, cut the engine, and sat for a moment in the silence. 3 breaths slow. It was not meditation. It was the ritual that stood between the version of her that existed in Courtroom 14B of the United States District Court, robed presiding absolute, and the version of her that existed here on this driveway, in this cold, who needed to eat something and sleep for 6 hours before the alarm went off. She reached for her leather briefcase on the passenger seat. It was heavy tonight, heavier than most. Inside were 47 pages of sealed pretrial motions for the Haverford racketeering case, 3 sets of annotated case law, and the wiretap authorization she had reviewed and signed at 4:30 that afternoon. The 7th in the case, a routine federal order allowing the FBI's Financial Crimes Unit to monitor communications between Martin Haverford's personal attorney and a known associate in the Cayman Islands. She had read every word of the supporting affidavit. She had annotated 3 concerns. She had satisfied herself that the constitutional standard was met. She had signed. That signed document now sat in her briefcase. In 3 days, the Haverford trial would begin. Tonight, she just needed to get inside. She stepped into the cold, real cold, the kind with teeth blowing off the coast on a northwest wind, and walked up the stone path between the ornamental boxwoods toward the front door. The motion sensor light above the mahogany entryway flickered on, casting pale yellow light over the porch. She loved that door. Original to the house, installed in 1927, solid enough to communicate something without saying a word. Permanent, not going anywhere. She found her house key by feel, inserted it into the antique brass deadbolt, and turned. The key did not turn. She tried again, not the smooth resistance of a locked bolt, but something rougher, mechanical wrong. She pulled back slightly, reseated. It applied more careful pressure, felt the slight give. The micro-fracture. And then with a sensation that traveled unpleasantly from her fingertips up through her wrist, the key snapped. She stood with half the key in her hand, the other half lodged in the deadbolt, and let herself be tired for exactly 1 moment. Just one. Then she straightened, reached for her phone, and pulled up the number for Diamond Locksmith Services. She did not hear the cruiser coming. Above the doorframe, fitted so precisely into the carved oak molding that a visitor would need to know exactly where to look, a small wide-angle security lens caught the first pulse of blue and red light washing across the wet asphalt of Halcyon Drive. The motion sensor registered activity. The recording began uploading in real time to an encrypted federal server capturing everything in 4K resolution with omnidirectional audio, the way it had been designed to do since the day the U.S. Marshals Service recommended that all federal judges in the district review their home security arrangements. Renee had installed it 2 years ago and never once needed to check the footage. That was about to change. Officer Dale Mercer had been patrolling the 9th District for 17 years. And in those 17 years, he had developed what he called an instinct. He used the word with pride the way some men used experience or wisdom, as though time had distilled something essential in him, had sharpened his perception into a clarity that younger officers simply didn't yet possess. What Dale Mercer called Instinct 14 official use of force complaints called something else entirely. The complaints lived in a file on the 4th floor of the 9th District precinct. But they didn't live there in any active sense. Over 17 years, they had been reviewed, documented, and systematically neutralized through the reliable mechanism of Bill Dawson, the Fraternal Order of Police Union representative, who played Thursday evening poker with Captain Morris Hendricks and who had a gift for language that transformed excessive force into dynamic response to perceived threat and racial profiling into pattern recognition based on environmental indicators. Dawson was not a stupid man. He was a precise man, and precision in the service of the wrong ends is one of the most dangerous things in the world. At the precinct, they called Mercer the Closer, a reference to the fact that he never left a scene without a collar. He had a gift for finding reasons for locating the angle that turned a routine stop into an arrest for escalating situations just far enough that the subject did the thing that gave him cause. The newer officers studied him. The smarter ones felt a creeping unease they couldn't always name. The ones who tried to name it found themselves on cold case assignments. At 44, Mercer was broad-necked and heavy-moving through the world with the physical confidence of someone whose size and badge had resolved most disagreements before they started. His philosophy, never written, communicated in 1,000 daily actions, was simple suspicion is probable cause, and the badge is the final word. He had never been seriously challenged on it. He expected he never would be. Beside him in Unit 3317 sat Officer Kyle Reston, 27, 8 months out of the academy, lean-wound, tight, not yet certain which instincts to trust and which ones to be afraid of. He had been assigned to Mercer's unit as part of the field training program. He had not asked for Mercer. He had not been given a choice. In 6 months, Reston had learned a great many things. He had learned how to write an incident report that said everything and revealed nothing. He had learned the wording that transformed, "I stopped this person because of the color of their skin," into suspicious behavior consistent with criminal intent. He had learned that Mercer had a specific quiet reaction to expensive cars driven by black men or black women through neighborhoods where in Mercer's calculation they had no organic reason to be a narrowing of the eyes, a slight forward lean, a hand that drifted to the door handle before any rational assessment had been made. He had also learned that voicing any discomfort produced a response so cold and complete that silence was easier. He had learned this in the 3rd week. He had not forgotten it. On the night of February 6th, Mercer was running the final hour of a double shift, tired and bored, in equal measure, a dangerous combination for a man whose filter was already thin. He was rolling through Maplewood Estates, which the 9th District patrolled twice nightly under an arrangement with the Residents Association, when he saw the figure on the porch, a black woman in a dark coat appearing to work a lock on a $2.3 million Colonial. He saw it from half a block away and made the decision before he had consciously formed a thought. He killed the headlights, slowed to a crawl, pulled to the curb. "Look at that," he said quietly. Reston leaned forward. He saw a woman in a trench coat at a front door. He saw the late model sedan in the driveway, clean, expensive, registered presumably to the house. He noticed the motion sensor porch light was on, which suggested the woman had been standing there long enough to trigger it. "She doesn't look like a prowler," Reston said carefully. "Look at the car in the driveway. Maybe she's locked out." Mercer was already reaching for the door handle. "In Maplewood, don't be naive, kid." He straightened one hand on the door, the other reaching for the spotlight. "Let's light her up." Reston opened his mouth, closed it, got out of the car. In the world of the United States District Court, there was a particular phenomenon that attorneys who had appeared before Judge Renee Washington described to those who hadn't. It wasn't about her rulings, though her rulings were consistently precise and rarely overturned on appeal. It wasn't about her questioning from the bench, though her questions had a way of locating the exact structural weakness in an argument with surgical accuracy. It was something more fundamental. It was the quality of silence that descended over Courtroom 14B when she took her seat, not the performed hush that follows a bailiff's all rise. Something earned. Something that came from 26 years on the federal bench, a decade as a federal prosecutor before that, and 7 years before that as a public defender in the overworked, underfunded criminal defense system of Trenton, New Jersey, where a 19-year-old named Marcus, her cousin, had met his court-appointed attorney for the first time 20 minutes before his arraignment, and where something had been installed in 14-year-old Renee Washington that never fully unwound. Not bitterness, something more useful than bitterness. A specific, productive, converting kind of anger that had propelled her through Georgetown law, through the federal public defender's office, through the U.S. Attorney's office, and finally to the bench, where she had spent the last 15 years doing the work she had always understood as the only real answer to what happened to Marcus. She was at 54, one of the most respected federal jurists in the district. She was 3 days from presiding over the largest racketeering trial in the district's history. And her briefcase, currently sitting on the porch railing beside the mahogany door, contained the signed wiretap authorization that kept the Haverford investigation alive. The signature on that document was the reason the 9th District's Financial Crimes Unit had been able to monitor Haverford's offshore communications for the past 60 days. Without her signature, the wiretap had no legal foundation. Without the wiretap, 2 years of federal investigation risked collapse. Officer Dale Mercer did not know any of this. The security system installed at 3317 Halcyon Drive had been built to federal specification after the U.S. Marshal Service advised all district judges to review their home security. The camera above the door was embedded in the architectural molding so precisely that it was invisible to anyone who didn't know where to look. It recorded 4K video with omnidirectional audio uploaded in real time to an encrypted fascist federal server. Renee had never needed to review a recording. Tonight, the camera had been running for 43 seconds when the cruiser's spotlight found her. The light arrived without warning, not a gradual brightening, but a detonation of white 1,000,000 candela, hitting Renee Washington all at once with the physical force of something solid. It erased the porch, erased the door, erased the amber warmth of the motion sensor light, and replaced everything with a blinding flat white that registered as pain before her eyes could respond. She dropped her phone. It cracked against the flagstone, and she registered the sound distantly. Both hands flying up reflexively, one gloved palm pressed against her eyes. Body turning instinctively away from the source. She blinked hard, forcing her pupils to respond, and heard simultaneously 2 car doors opening and a voice booming through a vehicle PA system with the specific register of a command that had bypassed the question phase entirely. "Step away from the door. Hands where I can see them. Now!" Renee breathed. In through the nose, the cold air sharp and clean out through the mouth. She had been in rooms with aggressive men her entire professional life. She had sat beside clients who were frightened and guilty, and sometimes both. She had presided over proceedings where the emotional temperature was high enough to make the air vibrate. She knew how to be still in conditions designed to produce panic. She turned slowly, hands spread wide and visible at her sides, left hand holding the phone, right hand holding the broken half of the brass key. She kept her chin level, looked toward the cruiser, and called out in the carrying voice she used when projecting to the back of a courtroom. "Officers, there is no problem here. I live at this address. My key broke off in the lock. I was calling a locksmith. Ain't I?" The cruiser doors were open, two figures moving toward her on the stone walkway. The first one came into the porch light's range, first, large, broad, moving with a forward weight distribution that communicated aggression before a single word had passed between them. His hand was on his holster palm, resting on the grip with the territorial familiarity of someone who had been doing this long enough that the gesture was unconscious. Name tag, Mercer. His eyes moved from her hands to her face, with an expression she recognized not from the abstract, but from 2 decades of watching it operate on other people in courtrooms and police reports, and the testimony of witnesses who struggled to make juries understand what it felt like to be on the receiving end of it. He had already decided what was happening. He was simply executing the decision. The second officer, younger, hanging back, looked at the sedan in the driveway, looked at Renee. Something moved across his face that was not empathy, but was the preliminary form of it, doubt. Mercer stopped at the base of the porch steps, with his hand still on his weapon, and looked up at her without slowing, without softening, without any of the routine courtesies the handbook specified as appropriate opening for a residential contact. "I said step down from the porch. Now." Renee frowned. The hostility was naked without pretense. She kept her hands visible, kept her voice even. "Officer, lower your voice. You are on my property." Measured clear, the voice she used when a witness was beginning to understand the direction of her questioning. "My name is Renee Washington, and this is my residence. The vehicle in the driveway is registered to this address in my name. If you give me a moment to retrieve my identification from my briefcase, which is right there on the railing." "Yeah, I didn't ask for a life story." Mercer closed the distance, stopping 3 feet from the bottom step, letting his physical bulk do the work it was accustomed to doing. "You don't reach into anything. You walk down these steps right now, or I come up there. You will do no such thing." Her voice dropped a full register, the shift that happened in her courtroom when she was done with the preliminary portion of proceedings and had moved into something more definitive. "You are completely out of line, Officer Mercer. I am a federal judge. You are standing on private property, issuing unlawful orders to a homeowner who has committed no infraction. I am telling you to de-escalate this situation before you make a mistake you cannot undo." For a fraction of a second, one fraction gone almost before it formed, something crossed Mercer's face. A flicker, a blink, and then it was gone, replaced by something worse: amusement. The performed disbelief of a man playing to an audience only he could see. A federal judge. He said it like he was repeating a punchline. Turned his head slightly toward Reston. "You hearing this? Watch her hands." Reston took a half step toward the sedan. "Mercer, maybe I should run the plate." "Shut up, Reston." The 2 words landed like a door being slammed. Reston went still. His jaw worked once. He looked at the ground. Renee watched this exchange with the comprehensive attention she brought to testimony that was about to become important. She understood with the clarity of someone who had spent 30 years studying the architecture of power and its abuses that there was no version of this conversation that ended on the porch. She had seen this before. Not precisely this, not herself in handcuffs, not her own door, but this dynamic. A man fully committed to a narrative backed by a structure that had never required him to revise it. She lowered her voice one more register. The wind dropped for a moment, as though the night itself was listening. "Officer Mercer." Each word placed deliberately, the way she placed words when she wanted them to stay in a room long after they were spoken. "I am going to say this once more, and I am asking you to hear it. My name is Renee Washington. I am a sitting federal judge of the United States District Court. This house, this vehicle, this address, all of it is mine. All of it is verifiable in 60 seconds if you run that plate. The key is broken in the lock. I arrived home from court 20 minutes ago. I signed a federal wiretap authorization at 4:30 this afternoon that is currently inside that briefcase on the railing. She held his eyes. I am asking you for the last time to de-escalate before you make a mistake that goes far beyond your career. She watched the words move across his face without penetrating. She watched him hear the authority in her voice and translate it in whatever internal mechanism she had spent her career trying to understand and dismantle into provocation, into defiance that required a response. She saw the muscle in his jaw tighten. She saw the hand on the holster grip shift. She saw a half second before it happened that he had made the decision. He came up the steps in 2 strides. No warning, no further instruction. Just the sudden, overwhelming physical reality of him. The smell of coffee and synthetic fabric. The geometry of his size reducing the porch to something much smaller than its actual dimensions. The hand leaving the holster and moving to her coat. He grabbed her by the lapel of her trench coat, the good wool one bought on Michigan Avenue 8 years ago, worn to every significant professional occasion since, and yanked her forward with a force that used her own surprise against her. The world rotated. The amber light and the white light and the cold night air all blurred together in a single nauseating arc, and she felt her briefcase leave the porch railing and heard it hit the flagstone and then the mahogany door. The impact was total. Her left cheekbone struck the solid wood at a velocity her body had not chosen and could not absorb, and the sensation was not quite pain. Not yet pain would arrive in a moment, but something preceding it. Something more fundamental. A white flash behind the eyes. A sudden irrelevance of everything except the fact of the impact and the vibration it sent through the architecture of her skull. She heard from somewhere that seemed very far away, someone yelling, resisting. Stop resisting, Mercer. His voice immediately after the impact, loud and declarative, and entirely unprompted, a narration being constructed in real time, laid over a reality that bore no connection to it. She registered this, filed it. Her face was against her door, and she could see the grain of the mahogany wood from an inch away, the long reddish-brown lines of it, the small variations in tone, the history of the wood encoded in its surface, and she was aware of her left arm being wrenched behind her. The shoulder joint protesting the angle with a searing precision that cut through the shock, and Mercer's forearm pressing against the back of her neck with the deliberate crushing weight of someone who had learned exactly how much pressure was required to keep a person compliant without leaving marks that didn't fade. "Take your hands off me." She said it into the wood. Her voice came out quieter than she intended. Her cheek was against the door, and the breath required was harder to find with the forearm on her neck. But she said it, clearly. "For the record, you are assaulting a federal officer. You are destroying your life right now. Shut your mouth." His voice was close, hissing. She felt his grip on her left arm increase, felt the joint being leveraged past its comfortable range toward the precise boundary of structural damage, the place where tendons communicate with the brain in purely binary terms. She made a sound that was involuntary, and that she would have prevented if she could have. From behind her and to the right, Reston's voice. Higher pitched, carrying the specific pitch of someone who has just recognized the scale of what is happening and is nowhere near equipped to stop it. "Mercer, Jesus. Grab her other arm. Cuff her." She felt the second set of hands on her wrist trembling. She registered this and filed it, and then the sound. The specific mechanical certainty of handcuffs, click, click, click. She had heard that sound thousands of times. In her years as a public defender, sitting beside clients at booking. In her years as a prosecutor building records. In her years on the bench, reviewing transcripts. She had heard it across courtrooms and in testimony and in the police reports that crossed her desk in quantities large enough to constitute a career. She knew its meaning from every direction. She had never heard it from this angle. She had never felt it on her own wrists. The cuffs were too tight. She felt it immediately steel, biting into the skin above her wrist bones, pressing against the tendons and vessels there with a pressure that would leave marks. She would have bruises. She noted this the way she noted an exhibit being entered into evidence. They pulled her away from the door. She caught a brief blurred glimpse of her own reflection in the small decorative glass panel beside the frame, a black woman in a trench coat, hands behind her back. Blood on her face, standing in the porch light of the house she had earned. And then they were moving, walking her down the porch steps, and she kept her spine straight and her chin level. Because there was nothing else left to her, and she was not going to give him the additional satisfaction of watching her falter. On the flagstone in the bottom of the steps, her leather briefcase lay on its side. In the porch light, the gold-embossed lettering on the front panel was clearly visible to anyone who looked. The Honorable R. Washington / U.S. District Court. Reston saw it. She watched him stop. She watched him read it. She watched the color leave his face with the particular speed of someone processing information that cannot be reconciled with what they have already committed to. Mercer keyed his radio before the cruiser had pulled away from the curb. She heard every word, the mic open, dispatch acknowledging, the words going into the official record with the permanence of anything that gets time-stamped and filed in a federal proceeding. Dispatch, this is Unit 3317. B and E suspect in custody. 3317, Halcyon Drive, Maplewood Estates. Suspect was combative at the scene. Attempted to reach for my weapon. Reasonable force was utilized to effect the arrest. Requesting case number. The dispatch operator assigned one. Noted the time 11:54 p.m. Every fabricated word now official, now documented, now permanent. Renee memorized it. She was exceptionally good at memorizing, had been since law school, had refined it across 3 decades of proceedings where the precise wording of things was the difference between freedom and incarceration. She memorized Mercer's exact phrasing, the way she memorized the exact phrasing of an evasive witness with the specific attention of someone who intends to return to it later in a context the speaker will not enjoy. She also memorized the badge numbers. Read them as they walked her to the cruiser, clearly visible on each officer's chest in the cruiser's ambient light. Mercer 3317, Reston 4409. She turned the numbers over in her mind twice to fix them, then set them aside. The drive to the precinct was 4 miles. Neither officer spoke for the first 2. Through the mesh divider in the cruiser's interior light, she could see the back of Reston's neck, the way it went rigid, and then slowly released the physical grammar of a young man absorbing something he did not know how to carry. He had picked up the briefcase. She had watched him read the embossed lettering. She had watched the blood drain from his face. She had watched him show it to Mercer. She had heard Mercer scoff, "Anybody can order a monogrammed bag, kid," and she had noted the fractional hesitation before the scoff. The micro pause of a man encountering doubt and choosing for the 1700th time in his career to override it. This was the specific shape of the problem. Not malice alone, though malice was present and real, but malice reinforced by 17 years of an institutional structure that had taught Mercer the override was always available. That the doubt could always be pushed down. That the system would accommodate whatever story he told it because it always had. He was not a stupid man. He was a man who had been educated through hundreds of repetitions of the same lesson that he was not subject to the same consequences as other people. He had absorbed that lesson so thoroughly that even now, with her in the back seat and the briefcase on the passenger seat and the gold lettering right there in the light, he was already building the story that would get him through this. She could tell from the set of his shoulders. She could tell from the rhythm of his breathing, which had slowed and steadied in the way breathing does when someone has made a decision and is in the process of executing it. She watched the city pass outside the cruiser window. The late amber of empty commercial streets. The dark rectangles of closed storefronts. The occasional lit window of someone awake at midnight who did not know what was happening in the back seat of this vehicle. And she thought with the methodical clarity she had always been able to locate in the center of disorder about what came next. She had a camera. She had an audio recording that would include Mercer's fabricated dispatch call, time-stamped and case-numbered going into the official record. She had a witness in the front seat whose face had communicated everything he couldn't say out loud. She had injuries that needed to be documented before they changed. She had in the briefcase on the passenger seat a federal wiretap authorization bearing her signature, which meant she could establish her identity title and jurisdiction for anyone with a computer and 30 seconds. And Mercer didn't know about the camera. He had walked up her porch steps and done what he did and walked away, believing the only evidence was his own account. He had no idea that above the doorframe, fitted invisibly into the carved oak molding, a lens had been recording in 4K with omnidirectional audio since the moment his spotlight lit up the wet asphalt of Halcyon Drive. He had no idea that the footage was already uploaded, already sitting on an encrypted federal server, already irrefutable. The cruiser turned into the 9th District Precinct lot. Renee straightened in the back seat, set her jaw against the pain in her cheekbone, and prepared for the next phase. He thought he had all the power. He had handed her every single piece of it. The 9th District Precinct at midnight was a controlled chaos of overlapping realities, the officers coming off the late shift, the detectives on overnight, the holding cells along the east wall, producing their irregular percussion of voices and distress. Mercer walked Renee through the double glass doors with his hand on her arm, not supporting gripping, and scanned the room with the expression of a man expecting an entrance to be appreciated. "Got a B&E suspect who decided to get froggy," he announced to the room, generally with the casual bravado of someone confident of a sympathetic audience. His voice carried. Behind him, Reston came through the doors carrying the briefcase with both hands slightly away from his body, with the careful deliberateness of someone transporting something that might be unstable. Desk Sergeant Frank Okafor did not immediately look up. He was deep in a property damage report that had been sitting on his desk since the previous afternoon, and he grunted in the general direction of Mercer's voice. "Name Jane Doe for now. Refused to ID. Claims she's a judge." Mercer's tone carried a built-in chuckle. He shoved Renee toward the booking counter with unnecessary forward pressure. "Get ready for a show, Frank." Okafor set down his pen, sighed, looked up. He had 22 years on the job. He had testified in Renee Washington's courtroom 8 months ago, the Prescott Securities fraud case, and he had sat in the witness box for 2.5 hours, answering her questions with careful precision, and he had been struck, as everyone who appeared before her was struck by the absolute comprehensiveness of her attention. The sense that nothing said in her presence was going to pass without being weighed. The pen fell from his fingers. It clattered on the linoleum with a small sound that in the suddenly significant silence of what happened next seemed very loud. He saw the handcuffs. He saw the swelling along the left cheekbone already purpling at the center. He saw the dried blood tracking from a cut above the eyebrow down the left side of her face. And then he looked at her face, actually looked at it, and his brain completed the process of placing a face from one context into an entirely different context with a recognition that took 3 seconds and felt considerably longer. Frank Okafor stood up slowly. His chair rolled back and struck the filing cabinet. He gripped the edge of the desk with both hands, and the color left his face in a comprehensive inside-out wave of cold. He looked at Renee. He looked at Mercer. He looked at Renee again. "Mercer," he said. The word came out barely audible. He cleared his throat. "What have you done?" It was not a question. Mercer's bravado developed its first fracture. Not a collapse, a hairline thing, a fine stress crack running through the performance of certainty he had been projecting since Halcyon Drive. He heard something in Okafor's voice he had not anticipated, and the not anticipating of it shifted something in his stance. But Mercer was not a man who retreated from doubt. He charged at it. "Caught her trying to pop a lock in Maplewood Estates," he said louder than necessary. "Volume a substitute for conviction. She was erratic at the scene. Refused to ID. Became physically combative when I attempted a standard pat-down. Made an aggressive motion toward my weapon. It's a clean collar, Frank. Don't give me that look." He said it with the authority of repetition, as though saying it with enough confidence could make it true by force of delivery alone. He looked to Reston for the corroborating nod that would transform one officer's story into a consensus. Reston was looking at the briefcase in his hands. Okafor came around the counter. moving faster than a man his size and age had any business moving with the direct purposefulness of someone who has made a decision and is executing it without internal debate. He reached Renee in 4 steps, pulled the cuff keys from his belt, and unlocked the handcuffs himself, without asking Mercer, without acknowledging Mercer's seniority, without any of the deference that 17 years of institutional hierarchy normally demanded. Renee brought her arms forward slowly, winced as circulation returned to her fingers. Okafor watched her wince, and the muscle in his jaw moved once hard like a door being shut. "Judge Washington." He stopped, looked at the swelling on her cheekbone, the blood, the redness at her wrists. He looked like a man searching for something adequate to the magnitude of what he was looking at and discovering that nothing adequate existed. "Your Honor, do you need a paramedic?" "It's been a while since the Prescott trial, Sergeant Okafor," she said quietly. At those words, Judge Washington Dale Mercer took a physical step backward, not a voluntary motion, the involuntary retreat of a body responding to a threat the conscious mind hadn't fully assembled yet. His mouth opened. No sound came. He looked at the woman he had walked through those doors in handcuffs. The tailored coat, the absolute composure, the face that was bleeding and calm simultaneously. And something fundamental shifted in the architecture of his certainty, and the space where the certainty had been filled immediately with cold. It lasted perhaps 3 seconds. Then his survival instinct honed across 17 years of situations that required quick, decisive narrative construction, locked in like a gear engaging. He had a plan. He had always had a plan. The system had always accommodated his plans. He looked at Reston. His eyes communicated an instruction. Reston looked at the floor. "Locker room," Mercer said quietly. His hand closed on Reston's arm. "Now." Reston allowed himself to be steered. His face as he passed Renee was the face of a man walking away from something he understood at some level that was deeper than his ability to act on it, that he would spend a long time reckoning with. Renee Washington sat down on the hardwood bench in the open booking area. She declined Okafor's offer of his office. She declined the coffee. She declined the ice pack with a specific explanation. She wanted to remain in the open, in the area covered by the station security cameras, with her injuries in their current state. She folded her hands in her lap. She was not merely a victim waiting to be helped. She was a federal magistrate gathering evidence, and she intended to stay exactly where she was visible and documented until the process that had already been set in motion by a camera above her front door completed itself. She looked at the fluorescent lights for a moment. She thought about the 47 pages of sealed motions in the briefcase, currently sitting on the passenger seat of Mercer's cruiser. She thought about the Haverford trial in 72 hours. She thought about the wiretap authorization bearing her signature, and about what it would mean legally, institutionally, in terms of the investigation's integrity, once the full dimensions of tonight became part of the federal record. Then she thought about Mercer in that locker room right now, building a story that the camera had already destroyed. She thought about him signing his name to it. She almost felt sorry for him. Almost. The locker room of the 9th District smelled of institutional detergent, and the compressed anxiety of shift changes, a smell built into the walls over 20 years. At this hour it was empty except for 2 men, and the emptiness made it feel very large and very small at the same time. Mercer paced. He had been pacing for 3 minutes long, for him not a natural pacer. The physical manifestation of a mind applying its considerable talent for narrative construction, under conditions of maximum pressure. He was sweating through his uniform shirt. His coffee from 10 o'clock was producing an acidity in his stomach that felt like something being eaten through. Reston stood at his locker with one hand on the door, not opening it. He had not spoken since they came in. "Okay." Mercer stopped, turned. His voice carried the focused energy of a man who has arrived at a decision and is committing to it fully. "Listen to me, Kyle. I need you to actually listen." Reston looked at him. Under the flat fluorescent light, he looked young in a way the past 6 months had been rapidly aging and simultaneously older than he should have been. "I know what you're going to say." Reston started. "Then I'll skip it." Mercer sat on the wooden bench, pulled an incident report form from his clipboard, found a pen. "Here is what happened. We observed suspicious activity consistent with B&E at a Maplewood Estates residence. Upon approach, the suspect was uncooperative and erratic. She refused to identify herself. She smelled of intoxicants. She didn't smell of anything. Kyle. Mercer's voice went patient. The patience was its own kind of threat. She smelled of intoxicants. Upon my approach to conduct a standard officer safety pat-down, the suspect became physically combative. She struck me in the chest. She made an aggressive motion toward my duty weapon. He was writing as he spoke, hand moving fast. Reasonable and necessary force was utilized to subdue the suspect and effect a lawful arrest. He signed his name at the bottom with a violent, committed flourish. Your supplemental report says the same thing. Clean, simple, consistent. Reston had not moved from his locker. He was looking at his hands. She's a federal judge, Trent. She says she's a federal judge. Her briefcase says she's a federal judge. Mercer set down his pen. He turned to look at Reston with a controlled expression that was working harder than it appeared. I've seen federal ID counterfeits in this job that would fool a magistrate. You think someone running a grift in Maplewood doesn't come prepared? He paused. And even if she is, especially if she is a federal judge, understands how quiet settlements work. The last thing she wants is her face on the news attached to a resisting arrest charge. The chief will call her people. Her people will call our people. The charges disappear. The complaint disappears, and everyone goes home quiet. He tapped the pen on the form. The only way this becomes a problem is if the story falls apart. And the only way the story falls apart is if I don't back your play. Reston's voice was flat. Right. There was no smell of alcohol. Reston said each word separately, the way people speak when they need the words to stay distinct from each other. She did not reach for your weapon. The key was broken in the lock. We both saw the car in the driveway. I wanted to run the plate, and you told me to shut up. He looked up. I'm not going to federal prison for a lie, Trent. Mercer stood. He crossed the distance between them in 3 steps and used all of his 40 additional pounds and 6 additional inches to occupy as much of Reston's immediate space as the room allowed. Reston held his ground. Barely. You are 8 months out of the academy, Mercer said quietly. Quiet was worse than loud. No commendations. No record worth mentioning. A performance review I write and sign. If you don't back my play, I tell Internal Affairs you initiated the physical contact. I say you panicked, and I had to step in. Who do they believe, 17 years and 14 commendations, or a rookie who can't hold his weapon steady? He let that settle. You write your supplemental report. Same story. You sign it. And in 6 months, this is a footnote. Reston pressed his lips together. His breathing had quickened in the way of someone suppressing a physiological response. She's a federal judge, he said again. Quieter now, almost to himself. She's a woman who is on a porch. Mercer picked up the clipboard. You've got 15 minutes. Don't make me come back for it. He left. Reston stood alone in the locker room for a long time. He looked at his hands. He looked at the blank supplemental report form on the bench. He looked at the door through which Mercer had just walked. He picked up his pen. He set it down. He put both hands over his face, and in the silence, and the fluorescent light, and the smell of detergent, the tears came quietly and without resolution. And 40 feet down the hallway, a woman sat on a hardwood bench with dried blood on her face, building her case. 34 minutes after Renee Washington was walked through the front doors of the 9th District Precinct, the heavy glass doors opened again, and the quality of that opening was different from every other opening they had experienced that night. Different in speed, different in the weight of what came through them. Chief of Police Gerald Harmon was 61 and had spent 30 years in law enforcement, and he had learned over those decades to read the temperature of a room from the threshold. What he read when he walked through those doors at 12:41 in the morning produced an understanding so complete and so cold that it bypassed his professional instincts entirely and went straight to something more fundamental, the specific physical recognition of a disaster that cannot be undone, only accounted for. He was wearing a tuxedo. He had been at the Westfield Foundation Gala when Okafor called. The call had been brief and carefully worded, and Harmon had needed to ask twice before his mind would accept the literal meaning of the words, because the meaning kept sliding away from him, kept being replaced by something less catastrophic, something more manageable. He had left without his coat. He had been in the building in 19 minutes. Behind him, matching his pace, exactly walked Special Agent in Charge Marcus Webb of the FBI's Regional Civil Rights Division. Webb was 49 and lean-moving with the self-contained efficiency of someone who had spent 2 decades in high-intensity investigative work and had learned long ago that urgency didn't need to be performed. His dark suit was immaculate. His gold shield was clipped to his belt. He had been on the phone for most of the drive, and the calls had been brief and precise and had involved words like federal jurisdiction and evidence response team, and I need that encryption key before I walk in. Harmon crossed the booking area. He saw Renee on the bench, the trench coat, the posture, the swollen cheekbone, the dried blood, and reached for a composure that was not fully available to him, because what he was looking at was not an abstraction, not a political liability, but a specific woman with a specific face that an officer under his command had put in its current condition. Judge Washington. His voice came out rough. He extended both hands in a gesture that was intended to be concern and somehow emerged as an apology, still searching for its form. Your Honor, I cannot begin to express. This is a catastrophic error. A catastrophic misunderstanding. Please, my office. Renee stood. She did not take his hands. She looked at him with an expression that was not unkind, but was entirely clear about the work that kindness was and was not available to do right now. There is no misunderstanding, Chief Harmon. Steady, carrying. Your officers did not mistake me for someone else. They saw exactly what they expected to see, and they acted on that expectation. I told them my name. I told them my title. I told them my address. I offered my identification. Officer Mercer chose not to hear any of it. Harmon opened his mouth. The appropriate response is not an apology to me. It is a federal investigation. She looked at Webb. Agent Webb, thank you for coming. Webb gave a minimal nod. He had been assessing the room since entry, the location of officers present, the security cameras, the geometry of the booking area as an evidence scene. He produced his shield. Judge Washington, are you requiring immediate medical transport? Num. I'm requiring that you secure the officers who assaulted me before they finish constructing their accounts. They went to the locker room 32 minutes ago. They have not emerged. Harmon found his administrative instincts. We'll conduct a full internal affairs investigation. I can have Captain Hendricks. Your department no longer has jurisdiction over this matter. Renee cut him off with the clean precision she used to cut off evasive testimony. This is a federal civil rights investigation under Title 18 United States Code, Section 242. Your Internal Affairs Division, which has processed and closed 14 prior complaints against Officer Mercer without adverse finding, is entirely recused. She paused. One beat. I've reviewed the complaint history, Chief. All 14, all managed by the same union representative, all closed without discipline. Another beat. I've been reviewing it for approximately 31 minutes. The number landed in the room with a weight that was almost audible. Harmon went still. Webb made a note. The locker room door opened at 12:47. Mercer came out first, clipboard in hand, uniform squared expression, arranged into a performance of composure that had clearly cost him some effort. He walked with the deliberate shoulders-back stride he used when the physical performance needed to carry weight that conviction alone could no longer supply. Behind him, Reston walked with no performance at all. He moved like a man carrying something heavy on the inside of his chest, something with no external expression, except in the particular quality of his stillness. Mercer saw the chief in his tuxedo, saw the man in the federal suit, saw the gold shield. His stomach dropped with a velocity that he felt physically a cold downward motion somewhere below the sternum. But his survival instinct overrode the drop before it reached his face. 17 years of practice. He kept walking. He reached the booking desk. He slid the completed incident report across the counter toward Okafor with the flat, controlled aggression of a man who has decided he cannot afford to stop performing. "Chief," he addressed Harmon without looking at Webb. "Incident reports for the arrest. Assault on a police officer, resisting arrest, suspected public intoxication." Standard B&E response protocol was followed throughout. The suspect became combative at the scene. The room stopped. Everything in it stopped. The ambient noise of a functioning precinct, phone's radio, chatter, the movement of bodies, all of it ceased in the way that sound sometimes ceases in the moment before something significant, as though the building itself was paying attention. Every officer at every desk had turned. The overnight dispatcher was standing. The clerk at the far end of the bullpen had not moved since Mercer walked out of the corridor. Chief Harmon looked at the report on the counter. He looked at Renee Washington's face. He looked at the report again. The expression that moved across him was the expression of a man watching two irreconcilable things occupy the same space, the story in the report and the reality in the room, and being unable to choose which one to accept as real. Webb looked at Mercer with the calm, detached focus of a man watching a subject build the cage he was going to spend the next several years inside and finding it almost clinically interesting from a professional standpoint. "Officer Mercer." Renee's voice was soft. In the total silence of the room, soft was more effective than loud. She let the syllables carry. Mercer looked at her. He kept his chin lifted. He was still in the performance. "Is that your sworn official statement?" "It is." He held her gaze. "Signed under penalty of perjury." She was combative. "She struck me and reached for my weapon. I used reasonable force." He said it looking directly at her. At the swelling on her cheek his hand had caused. At the blood his force had drawn. At the woman who had been standing on her own porch with a broken key. And he said it to her face. Renee held his gaze for 3 seconds. Then she turned to Webb. "Agent Webb, my house at 3317 Halcyon Drive is equipped with a biometric security system. Embedded in the architectural molding directly above the front door is a 4K resolution wide-angle camera with omnidirectional audio motion-activated recording directly to an encrypted federal server." She paused for one beat. The camera activated when Officer Mercer's spotlight hit the lens. It recorded the complete encounter, every word, every action, every second, before he ever got out of the car. Webb reached into his jacket and checked his phone. He had received a message. He read it. He gave a single, minimal nod. He signaled toward the precinct entrance. A field agent came through the glass doors. He crossed the room with practiced efficiency, reached the booking counter, and set a federal evidence bag down with a sound that was quiet and deliberate and final. Inside the bag, a small silver hard drive, rectangular the size of a deck of cards. The footage had been pulled from the cloud server from the parking lot outside. It had taken 11 minutes. The color left Dale Mercer's face. Not gradually, all at once. A single comprehensive withdrawal that left him the color of the cinder block wall behind him. His jaw still set, but the set changed no longer. The set of a performance, but the set of a structure under critical load. The clipboard left his fingers. He did not release it deliberately. He simply stopped holding it. It hit the linoleum with a sound that was disproportionately loud in the silence. "Officer Mercer," Renee said. Her voice had dropped to the register she used for final instructions, the voice that came immediately before the gavel. She held his gaze across the distance of the booking counter, across the gap between what he had done and what he had just sworn to. "You did not just assault a federal judge. You submitted a perjured sworn statement to the Federal Bureau of Investigation in a room containing the unedited evidence that contradicts every word of that statement. The camera was running before your spotlight hit my face. It captured your dispatch call. It captured the encounter in full. It captured your partner reading the lettering on my briefcase. One more beat. You didn't trap me on that porch, Officer Mercer. You walked into the camera's frame and trapped yourself." Mercer looked at Reston. Reston looked at the wall. The conference room at the 9th District Precinct was 14 by 16 feet of institutional beige, containing a long wooden table whose surface bore the history of 1,000 difficult conversations, coffee rings, pen grooves, a crack along the far edge that had never been repaired. The fluorescent light above it was the same as every other light in the building, but in this smaller room, it felt closer. More forensic. Mercer and Reston had surrendered their weapons and duty belts at the door. They were no longer acting officers. They were subjects of a federal investigation, and the adjustment required by that change in status was visible in both of them. In Mercer's hyperventilating, barely controlled his eyes moving around the room in the pattern of a man locating exits and finding they're all conceptual. In Reston's face down on his arms on the table's shoulders, moving in the irregular rhythm of crying held back until it wasn't. Renee sat in the corner, an ice pack finally held to her cheekbone. She'd accepted it now. The swelling at the stage where the documentation of appropriate first aid mattered. Her right hand rested on the table. Her left held the ice pack. She watched both men with the specific attention she brought to witnesses whose testimony she was about to hear. Webb opened his laptop at the head of the table. The evidence technician had connected the hard drive. The footage was loaded and indexed. Webb looked at the room. Nobody speaks until the footage is finished. He pressed play. The monitor at the end of the room came to life. The security system's night vision rendering was not the greenish monochrome of consumer cameras, but a full-spectrum high-definition image in which every detail of the porch at 3317 Halcyon Drive was as clear as midday. The stone path, the ornamental boxwoods, the warm cone of the motion sensor light, and in the center of the frame, a woman in a trench coat exhausted, fumbling with her keys, reaching for her phone. The audio was pristine. The omnidirectional microphone had captured everything: the northwest wind through the oaks, the distant sound of a passing car, and most critically, the sharp mechanical snap of the key breaking in the deadbolt. Sharp, unambiguous, documented. Then, the light. The cruiser's spotlight hit the lens and the aperture adjusted, and for a fraction of a second, the image washed white, and then it cleared, and there was Renee Washington. Hands spread and visible, slowly turning, calling out clearly. "Officers, there is no problem here. I live at this address." My key broke off in the lock. I was calling a locksmith. Chief Harmon, sitting to Webb's right, made a sound behind the hand pressed to his mouth. It was not a word. Every exchange on the porch was there. Every fabrication Mercer had committed to paper was now playing against its own refutation. His laugh when Renee stated her title, Reston's quiet suggestion to run the plate, and Mercer's bark of dismissal. The charge up the steps, the grab, the spin, the impact. The sound of Renee's face hitting the mahogany door came through the conference room speakers with the full, terrible fidelity of an omnidirectional microphone, preserving every frequency. It was not an abstract sound. It was not a sound that allowed any space for alternative interpretation. 2 jurors would weep when it played in the trial courtroom. In this room, right now, Chief Harmon flinched so hard his chair moved. Reston, face still on his arms, made a sound that had been building for 47 minutes. Then Mercer's voice, immediate, loud, unprompted, resisting, stop, resisting. A narration laid over a reality that bore no connection to it. Documented. Time-stamped, permanent. The video ran to its end, Renee being walked down her porch steps, head level, spine straight. Reston picking up the briefcase, the porch light catching the gold letters, the color leaving Reston's face. Mercer squinting at the lettering, scoffing, throwing the briefcase onto the passenger seat, and then went dark. The silence in the conference room was different from the silence before it. Before had been tension. This was something simpler, a single version of reality now established, now unchallengeable, sitting in the room with everyone who needed to reckon with it. Webb closed the laptop. He picked up a pen. He looked at Mercer. "Officer Mercer, I've read the incident report you submitted 20 minutes ago. Having just watched that footage in its entirety, would you like to amend your sworn statement?" Mercer's mouth opened and closed. He looked at Chief Harmon, who was looking at the table. Harmon would continue looking at the table for a very long time. Fast-moving situation Mercer managed. His voice had lost its essential quality. The projection was gone, the confidence gone. What remained was a smaller sound, the voice of a man operating without the armor. It had always worn dark. I perceived a threat based on experience and training. The suspect. The footage timestamp shows 58 seconds between your spotlight activating and your first physical contact with Judge Washington. Webb's tone was flat clinical. He turned his laptop briefly to show the timestamp. 58 seconds, during which she stated her name, her address, and her title. During which her hands were visible, holding a broken key. During which your partner attempted to run the license plate and you prevented him. He set the laptop down. What threat were you responding to specifically when you grabbed her coat lapel? No answer. Did you also perceive a threat when you dictated a sworn statement in which you alleged that she struck you and reached for your duty weapon actions, which appear nowhere in 58 seconds of high-definition footage? No answer. The chair beside Mercer scraped back with a violence that cut through the silence. Kyle Reston stood up. His face was wet. His chest was heaving. He looked like a man who has made the most agonizing decision available to him and is executing it before he can reverse it. He pointed at Mercer. His hand was not fully steady. He took me to the locker room. His voice cracked on the first word and held for the rest. He wrote the report out loud and told me to corroborate it. He said if I didn't, he'd tell Internal Affairs I started the fight. He slammed me into the lockers. He looked at Webb directly. She was completely calm on that porch. Her hands were visible. She gave him her name and her title and her address. He attacked her because she didn't cower to him. And then he dragged me to a locker room and tried to make me help him send a federal judge to jail for it. I am not doing that. I am not going to prison for this. I will tell you everything I saw that night and everything I watched him do in 6 months on his unit. All of it. Shut up! Mercer lunged half out of his chair across the table, the last animal motion of someone who has run out of every other option. Webb was on his feet before Mercer cleared the table edge. His hand went to his hip. His voice hit the room with the specific force of a man who does not need to perform authority because he simply is it. Sit down, right now, or I put you on the ground myself. The voice stopped Mercer cold. He looked at Webb's hand. He looked at Webb's face. And then, with the specific reluctance of something giving way under a load it can no longer support, he sank back into his chair. The last of the fight went out of him. The performance went with it. What remained was the frame of a man who had been for 17 years something very specific and armored and certain, and who was now none of those things, and who was discovering for the first time what was underneath. Webb straightened his jacket. He walked around the table with measured, unhurried steps. He stopped behind Dale Mercer's chair and unclipped the federal-issue handcuffs from his belt. The sound they made in the silence was clean and clear and final. Trent Mercer, the voice of the federal government carrying the weight of an institution that had been building this moment from the first second the camera above Renee's door began recording. You are under arrest for violation of Title 18 United States Code, Section 242. Deprivation of rights under color of law. Section 371 Conspiracy to commit an offense against the United States. Section 1621 Perjury. He took Mercer's wrists. He pulled them behind Mercer's back. He applied the cuffs. Click, click, click. The sound was identical to the sound Mercer had made on the porch of 3317 Halcyon Drive when he had restrained Renee Washington's wrists too tightly and walked her down her own steps. Identical in mechanism, entirely different in meaning, the same sound from opposite sides of what it means to hold authority over another person. 3 additional federal agents stepped into the conference room doorway. Behind them, visible in the corridor beyond the 9th District, had gathered. Not called, not ordered. They had simply come drawn by the sound of Reston's breakdown, by the quality of what was moving through the building, the way people are drawn to the sight of something they know will matter. 43 people filling the corridor, wall to wall. Okafor at the front, the overnight dispatcher at the back. A rookie who had been processing paperwork at the far end of the bullpen had walked the full length of the building to be here without quite knowing why. They stood in complete silence and watched Trent Mercer, the closer. The man whose name had been a kind of institutional weather in this building for 17 years, whose 14 complaint files had been managed into invisibility by a man who played poker. The captain walked forward in federal handcuffs through the space that had belonged to him, past the faces of people who had accommodated him, covered for him, looked away from him, been trained by his presence to look away, who were all at this specific moment not looking away. Nobody moved to help him. Nobody looked at the floor. The only sound was footsteps. Renee Washington stood from the corner chair. She set the ice pack on the table. She straightened her trench coat, the collar, the lapels, the belt. She picked up her cracked reading glasses from the table surface, examined the fracture in the left lens, and folded them into her pocket with the unhurried efficiency of someone who has 100 other things to do and is returning her attention to them. She crossed the room. She stopped a foot from Dale Mercer, close enough that he had to choose. He chose to look at her, the specific agony of that choice visible in the set of his face, and she held his gaze and spoke quietly enough that the words were for him alone. You relied on a system you believed would protect you, regardless of the truth, regardless of what the evidence showed, regardless of who was standing across from you. She held his eyes. That belief served you for 17 years because the system you're describing was real. It was maintained deliberately by people in this building who calculated it was in their interest. She paused. But you forgot one detail, Mr. Mercer. The system you were counting on to save you is the same system I work in. And in my system, the camera was running before you ever got out of the car. You didn't just assault a judge. You assaulted the judge who signed your department's wiretaps. You handed me everything. She paused one final beat. I am the system. She turned and walked out of the conference room without looking back. Down the corridor past the gathered precinct, past Okafor, who met her eyes and gave her one single nod, not a greeting, not a farewell, but an acknowledgement of what she had survived and what it had cost and what it was now worth. She went through the precinct doors and out into the February cold, and the parking lot's amber light caught the dried blood on her cheekbone and the absolute unbroken steadiness in her face, and the northwest wind was still blowing off the coast, and the city was dark and ongoing and real. The footage from the security camera at 3317 Halcyon Drive went public at 6:17 in the morning of February 7th. It hit every major national news network by 7 o'clock. By 8, 3 cable networks were running it in continuous loops. By the following morning, it had 62 million views across platforms, a number still climbing, driven not by the usual mechanics of viral content, but by the more durable engine of genuine, unambiguous public reaction to something that was genuinely, unambiguously wrong. There was no ambiguity to argue about. There was no split-second decision to contextualize. There was no moment where a reasonable observer could say, well, from his position, with his information, one could understand, because the footage showed 58 seconds of a woman standing calmly on her own porch with a broken key stating her name and title and address clearly and repeatedly, and a man who heard all of it and grabbed her anyway. The sound of the impact played through every speaker in the country before the morning was out. It was not a sound that accommodated interpretation. It was just the sound. The Fraternal Order of Police Local, Chapter 9, which had defended Mercer through 14 prior complaints, all closed without discipline, convened an emergency board meeting at 9:30 that morning. The meeting lasted 45 minutes. At 10:15, the chapter president issued a 2-sentence press statement. Mercer's membership was permanently revoked, and all financial support for his legal defense was withdrawn. The statement contained no expression of regret, no acknowledgement of the 14 complaints, no mention of Bill Dawson. It was a calculation of institutional survival, made with the efficiency of an organization that had practice in such calculations. The blue wall of silence had not merely cracked. It had dissolved in advance of any pressure being applied to it, because the people inside it had watched the footage and done the math. Mercer liquidated his pension contributions $22,000 after penalties, and took a second mortgage on his house to retain Warren Gill, a defense attorney who specialized in high-profile misconduct cases and who required a $30,000 retainer and charged $400 an hour and was the only attorney willing to touch the case. Mercer's wife, Patricia, watched the footage at the kitchen table while their daughters ate breakfast. She watched it twice. She went upstairs and packed a bag. She drove to her sister's house in Columbus that afternoon and filed for divorce from Columbus the next morning, citing irreconcilable differences accurate in a way that exceeded the legal definition. She froze the joint accounts. She did not return his calls. There was also a consequence that received less coverage, but that had profound implications for the district. The Haverford case, 3 days from trial, was placed under emergency judicial review. The assault on the signing magistrate triggered an automatic review of every wiretap authorization she had signed in the preceding 90 days to determine whether the integrity of those authorizations had been compromised by the events of February 6th. Martin Haverford's attorney moved immediately to have the wiretap evidence suppressed on the grounds that the authorizing judge had been subjected to violent intimidation by local law enforcement in a jurisdiction connected to the investigation. The motion was referred to a different federal judge for emergency ruling. It took 11 days to resolve. The Haverford trial was delayed by 3 weeks, during which the investigation's evidentiary architecture was reviewed line by line. The wiretap authorizations were ultimately upheld. The review found no connection between the 9th District's misconduct and the federal financial crimes investigation, but the delay cost the prosecution momentum and cost the city coverage it could not afford. Dale Mercer had assaulted a judge on her own porch to assert dominance over 60 seconds of a Tuesday night. The consequences of those 60 seconds were still being counted. The trial was scheduled 11 weeks after Mercer's arraignment, and the weeks preceding it had the specific quality of time experienced by someone who has lost control of what the time contains. Kyle Reston had entered a cooperation agreement 2 days after the arraignment. In exchange for his full and truthful testimony regarding the events of February 6th and his testimony regarding Mercer's conduct during their 6 months as partners, Reston would plead guilty to a single misdemeanor count of failure to intervene resulting in probation and the permanent surrender of his law enforcement certification. He would never carry a badge again. He had known this when he stood up in the conference room and pointed. He had decided it was the only cost he was willing to live with. The cooperation agreement made Reston the prosecution's primary witness. It also made him, in Mercer's increasingly desperate calculation, the single obstacle between Mercer and any viable defense. Warren Gill was building on 2 pillars that the footage, while devastating, didn't capture the totality of Mercer's threat perception and could be contextualized through expert testimony, and that Reston, operating under a plea agreement, had sufficient motive to shade his account in the prosecution's favor. It was not a strong defense. Gill knew this. He had said so explicitly. "I need one person on that jury. One person who can be convinced she escalated the situation. I can work with one person." He had also said explicitly, "You do not contact Kyle Reston. You do not contact anyone connected to this case. You are under a federal microscope. Every call you make is monitored." Mercer had nodded. He had said he understood. The isolation rotted him. He was released on modified bail, $180,000, secured against the second mortgage with electronic monitoring and a curfew. And he went home to a house that Patricia had half emptied of herself and the girls. And he sat in the kitchen where the girls used to do their homework. And he drank cheap bourbon. And he thought about Kyle Reston. In the dead of night on a Thursday, in his 4th week of release, Mercer drove to the Quick Mart on Route 9 and bought a prepaid phone with cash. He drove to the parking lot of a closed hardware store 3 miles from his house and sat in the dark with the engine running and the burner phone in his hand. He dialed Reston's number from memory. 4 rings. The 5th ring answered. "Bryce." His voice was rougher than intended. "The bourbon. It's Trent. Don't hang up." "I can't. This violates your release conditions." "I know what it violates." The anger came fast, the way it always came fast now, without the uniform and the badge and the FOP, between him and the parts of himself that were harder to manage. "Listen to me. You don't know what the feds are going to do to you when they're done using you. They chew up cooperators, Bryce. You're a tool to them. You get on that stand and you say, Webb pressured you. You were confused. You didn't understand what you were agreeing to. I'm not doing that. You don't want to hear what happens if you don't. The threat came out before he had finished deciding to make it the way things come out at 2 a.m. with a half-empty bottle and a second mortgage and 17 years of impunity training you to believe that threats are things that work. Every cop in this state is going to know your name and your address. Every single one. You're going to spend the rest of your life looking over your shoulder, Bryce. I promise you that. Reston said nothing. He sat in the bedroom of his new apartment phone to his ear, following the instructions he had been given explicitly by the federal prosecutor's office. If Mercer calls and says anything constituting intimidation, do not respond in any way that would contaminate the recording. His phone had been set up to record automatically from the moment the cooperation agreement was signed. The FBI had anticipated this call with the calm of an institution that had seen this particular behavior before and had learned to position the net before the animal reached the edge. Mercer hung up. He threw the prepaid phone out the window into a storm drain on the way home. He felt for approximately 40 minutes the hollow and entirely false sense of having done something that would matter. At 7:15 the following morning, his front door came off its hinges. Not a knock, not a bell. The specific mechanical violence of a federal entry warrant executed by a battering ram, a sound designed not merely to open a door, but to communicate the nature of what was happening. The door folded inward on the second impact, and through the opening came a 10-man FBI tactical team, and the first instruction they gave, leaded in the register of people who are not negotiating, was to get on the floor. Mercer got on the floor. He was in a t-shirt and shorts. He had no badge, no gun, no union, no institutional protection, no story that was going to work in the next 30 seconds or ever. He had the hardwood floor cold against his cheek and the sound of the handcuffs clicking into place and a voice reading him his rights over the noise of the entry team. That afternoon in federal court, Judge Calvin Rhodes looked down at the transcript of the wiretapped call with an expression that required no interpretation and revoked Mercer's bail without deliberating. The defendant represents a clear and present danger to the integrity of these proceedings, Judge Rhodes stated. He is remanded to the custody of the United States Marshals and will be held at Wilford Federal Detention Center, maximum security, until the conclusion of trial. Mercer looked back at the gallery as the marshals came forward. The gallery was empty except for Jill's paralegal and 2 reporters. There was no union representative. There was no wife. There was just the room and the door opening and the cell beyond it. The trial hadn't even started. He was already living in a cage. Satellite trucks had been parked in the blocks surrounding the federal courthouse since before dawn. Inside courtroom 5B, every seat in the gallery was filled. Mercer sat at the defense table in a gray suit provided by the Wilford Detention Center, 40 pounds lighter than the man who had walked up the porch steps of 3317. Halcyon Drive, hollow-eyed, his bulk converted by weeks of institutional food and sustained stress into something that was structurally the same man, but entirely different in character. The swagger was gone. The armor was gone. What sat in the gray suit looked exactly like what it was, a frightened man waiting for consequence. DOJ prosecutor Diane Holloway was 44, compact, precise, with the physical efficiency of someone who does not waste motion. She had tried 23 federal civil rights cases. Her conviction rate was referenced in DOJ training materials. She had prepared for this one with a thoroughness that had required her staff to work through 2 consecutive weekends, and that had produced a case file whose organizational depth was, even for Holloway, exceptional. She presented the prosecution's case in 3 days. On day 1, she played the footage on the courtroom's surround sound system, in the highest available resolution, on monitors positioned so that every juror could see it with full clarity. She played it 3 times. First in silence, no commentary, just the footage from the first flash of the cruiser's spotlight to the final frame of the sedan's license plate in the driveway. Second, with a running timestamp visible marking the 58 seconds. Third, at half speed, pausing at specific moments, Renee stating her name, Renee stating her title, Renee offering her identification, Reston moving to run the plates, Mercer stopping him and holding each pause for a count of 5 before moving on. In the jury box, 2 jurors wept during the third viewing. The sound of the impact bone against mahogany, preserved in full fidelity, moved through the courtroom speakers, and 2 people could not hold what they felt when they heard it. On day 2, Holloway called Kyle Reston. He had been out of the department for 10 weeks. He looked hollowed in a way that was different from Mercer's hollowness. Where Mercer looked like something had been taken from him, Reston looked like something had been set down, like the weight of the person he had been made to be for 8 months had been finally at cost, released. He sat in the witness box in a plain blue shirt and answered Holloway's questions with the direct, unflinching quality of someone who has made a single comprehensive decision and is executing it without reservation. He testified to the night of February 6th in complete specific detail. Mercer's immediate characterization of Renee as a prowler before any observation that could have supported it, his own suggestion to run the plates, Mercer's refusal, the porch, the briefcase lettering, and Mercer's dismissal, the locker room pacing, dictating, signing, threatening, slamming him into the lockers, all of it. He said it looking at the jury, not at the defense table. When you were on that porch and observed Officer Mercer make physical contact with Judge Washington, Holloway asked, was there any action on her part you would characterize as combative or threatening? Reston looked at the jury. His voice was steady. No. She was completely calm the entire time. Her hands were visible. She told him exactly who she was, her name, her title, her address. She offered her identification. She warned him he was making a mistake. He paused. He attacked her because she didn't cower to him, because she talked back to him in a way he interpreted as disrespect, and because he had learned over 17 years that he could respond to that interpretation without consequences. I watched it happen, and I didn't stop it, and I'm going to have to live with that, but I'm not going to lie about it. Jill's cross-examination was competent and found no purchase. The wiretap recording of Mercer threatening Reston neutralized every line of attack before it landed. The jury saw not a compromised cooperator, but a terrified young man, bullied by a senior officer from the night of the offense through to the week before trial. On day 3, in the decision that Warren Gill would spend the rest of his professional life reviewing, he put Mercer on the stand. Mercer testified for 90 minutes on direct. He used the vocabulary of training and threat perception and split-second decision-making. Gill had prepared him well, and for 90 minutes the performance was adequate, if not convincing. Holloway approached the podium for cross. She had a yellow legal pad covered in handwriting. She rarely looked at it. Mr. Mercer, you've described your contact with Judge Washington as a split-second response to a perceived threat. She turned to the courtroom monitor where the footage was cued. The timestamp shows 58 seconds between your spotlight activating and your first physical contact. During those 58 seconds, Judge Washington stated her name. She stated her address. She stated her occupation. She offered her identification. She asked you to check the vehicle registration visible from where you were standing. Your partner attempted to do exactly that, and you stopped him. She set down her legal pad. Can you identify for this jury the specific moment during those 58 seconds when you perceived the threat that you were responding to? Mercer tried. He used non-compliant and erratic tone and failure to follow lawful instructions. Holloway walked through each with the footage pausing on the specific seconds each descriptor claimed to describe, and the jury watched the descriptor slide off the reality with nowhere to go. She was exercising her constitutional right not to be unlawfully seized, Holloway said. Is it your testimony that the exercise of a constitutional right constitutes a threat? She was non-compliant. She was on her own porch, with a broken key, asking you to check a license plate. Holloway's voice finally rose not in anger, but in righteous clarity. In the register that comes when the facts and the argument are perfectly aligned, and when you couldn't find a real reason to grab her, you went into a locker room and manufactured one under oath, under penalty of perjury. in a sworn federal document. She paused. Did your training and experience also teach you how to commit perjury? Mr. Mercer? I was scared, Mercer said. His composure had broken not dramatically, not in tears or raised voice, but in the quiet, comprehensive way that a performance breaks when the performer runs out of material. You don't know what it's like out there. You don't know what we deal with. Holloway looked at him for a long moment. Then she said quietly, the words that would be quoted in every subsequent article about the case, I know what Judge Washington dealt with. She turned her back to him and walked to her table. No further questions. The jury deliberated for 3 hours and 50 minutes. When the foreperson stood courtroom 5B, was so quiet, the overhead lights were audible, that faint, persistent hum, the sound of the building's infrastructure, the only noise in the room between the foreperson rising and her voice. Count 1 deprivation of rights under color of law. Guilty. Count 2 conspiracy to commit an offense against the United States. Guilty. Count 3 perjury. Guilty. Count 4 witness tampering. Guilty. 4 words 4 times. Read into the federal record with the calm finality of a door being closed on a room that will not be reopened. Mercer put his forehead on the defense table. He made a sound that was not a word and did not need to be. Jill closed his briefcase with the practiced efficiency of a man who understood that this moment, too, was a professional task to be executed without theatrics. In the second row of the gallery, Renee Washington sat with her hands folded in her lap. Her face had healed fully. The bruise was gone, the laceration above her eyebrow reduced to a faint line. She wore a gray suit she liked. Her briefcase was on the floor beside her. She looked exactly like what she was, a professional, attending a professional proceeding present because her presence was appropriate and because it mattered. She did not look triumphant. She did not look relieved in any simple sense. She looked like a woman watching the natural conclusion of a case she had always known would resolve this way. The marshals came forward. Mercer stood, and as he turned toward the gallery, his eyes found hers across the room. She did not look away. She did not smile. She did not give him the satisfaction of contempt or the comfort of anything that resembled mercy. She gave him the full, clear, undeflected attention she brought to everything. The same attention she brought to a case file, to a line of testimony, to the precise language of an opinion that needed to be right. And in that look was neither victory nor cruelty, but simply the complete, unwavering acknowledgement of what had happened, what it had cost, and what it was now worth. Then she reached into her briefcase. She pulled out a document. She uncapped her pen. She began to read. 6 months after the verdict, the federal courthouse was quieter. The satellite trucks were gone. The national news cycle had moved as it always does to the next story, but the Mercer case lived on in the law review articles, the civil rights briefs, the DOJ training materials, where it would do its work in the years ahead, compounding quietly. The gallery at the sentencing hearing was full but not frenzied. The people in it were there for specific personal reasons, the attorneys watching the case, the community representatives who had spent years documenting Mercer's conduct and who were here to see the documentation honored the journalists who understood that sentencing was in some ways the more consequential moment, the one that established permanent record. Renee Washington entered the well of the court at precisely 9 o'clock. Gray suit, new reading glasses, the same frames as the cracked ones, same prescription, because she had liked them and saw no reason to let the occasion of their damage become a reason to change what worked. She carried a single piece of paper, her victim impact statement, written the previous Thursday evening at her kitchen table alone after her clerks had gone home. She had written 6 drafts. The first 5 had said more than she wanted to say. She had cut them back until what remained was exactly as much as the court needed and nothing more. She stood at the podium. She looked at Judge Rhodes. She did not look at Mercer. Your Honor, her voice was the voice of the courtroom, measured, carrying clear. The physical injuries I sustained on February 6th healed within weeks. There are no lasting structural consequences to my shoulder, and the laceration above my left eyebrow has healed without scarring. I am physically intact." She paused for one breath. The deeper wound is not physical. It is the direct personal knowledge of how easily the truth can be buried when the person holding the false report also holds the authority of the state. What happened on my porch was not an anomaly. It was the outcome of a specific documented pattern of conduct that had been formally reported 14 times over 17 years and formally addressed 0 times. The mechanism that was supposed to prevent it had been captured by the very person it was supposed to constrain. She stopped. I was fortunate. I had a camera. I had a title. I had the specific knowledge and resources to navigate what followed. Most people do not have these things. On the nights when what happened to me happens to someone without a camera or a title, it does not end in a federal courtroom. It ends in a dismissal with prejudice and a notation in a file that no one reads. She looked down at the paper in her hands, then back up. I ask the court to ensure that Officer Mercer never again has the opportunity to use the authority of a badge as a weapon against the people that badge was issued to protect. I ask the court to recognize that this case is not only about what he did to me, it is about what the absence of accountability produces and what accountability, when it finally arrives, is worth. She stepped back from the podium. Judge Rhodes looked at Trent Mercer. Mercer was standing at the defense table, thinner still than at the trial. The gray detention suit now fitted to a smaller version of the man it had been made for. His hands were at his sides. His eyes were directed at a point on the floor approximately 6 feet in front of him that had apparently become very important. The arrogance was not subdued. It was not diminished. It was simply absent the way a quality disappears when the conditions that produced it have been permanently removed. Mr. Mercer, Judge Rhodes said, you were entrusted with a remarkable authority, the authority to deprive people of their liberty in service of public safety. That authority required, as its essential precondition, the judgment to exercise it without bias and the integrity to answer for it when you did not. You possessed neither. You used your badge as a personal instrument of contempt against a woman on her own property, and when confronted with the full weight of that decision, you attempted to use the machinery of your profession, sworn statements, official reports, the institutional apparatus of law enforcement, to imprison the person you had already harmed. He let that sit. The system did not save you. The system in this instance is the reason you are standing in it. He picked up his pen. On the count of deprivation of rights under color of law, this court sentences you to 11 years in federal prison. On the counts of perjury, conspiracy, and witness tampering concurrent terms, totaling an additional 3 years to be served consecutively to the primary sentence. He set down the pen. As your crimes were committed under the color of official authority, you are hereby stripped of your municipal pension. The liquidated value will be applied to restitution for the verified victims of your 14 prior adjudicated misconduct incidents, the complaint files for which are now formally reopened under federal consent decree. The gavel came down. Clean, final. The sound of an institution that has, after documented process, reached a conclusion not subject to appeal by sentiment. Mercer stood where he was while the marshals came forward. He did not speak. He did not look at the gallery. He went with the marshals, and the door through which he left was the same door that had received 100 verdicts before his and would receive 100 more, and it closed behind him with no particular ceremony. Kyle Reston received his sentence from Judge Rhodes. At the same hearing, 3 years probation, mandatory counseling, permanent revocation of his law enforcement certification. He accepted all of it without contest. He left the courthouse quickly alone without speaking to anyone, and the city received him back into the ordinary life of a man in his late 20s who is starting over and who has a very specific thing to start over from. Renee Washington returned to her bench on the Monday following the sentencing. Courtroom 14B was exactly as she had left it, cold marble, the federal seal, the particular quality of silence that descended when she took her seat. That silence had not changed. If anything, it was deeper. The Haverford trial, delayed 3 weeks by the judicial review triggered by her assault, had proceeded and concluded. Martin Haverford had been convicted on 11 of 14 counts. His attorneys motioned to suppress the wiretap evidence, the motion arguing that the authorizing judge had been subjected to violent intimidation by law enforcement connected to the jurisdiction, had been reviewed by a separate federal judge and denied. Renee had written a separate opinion on the matter, concurring with the denial, addressing the question of whether a judge's assault by unrelated officers could compromise the integrity of previously authorized surveillance. The opinion ran 12 pages. It was already being cited. The consequences of the Mercer case extended past the sentence. Bill Dawson, the union representative, who had processed and neutralized Mercer's 14 complaints, resigned his position 3 weeks after the verdict and was subsequently named as a co-conspirator in one of 3 criminal referrals arising from the reopened complaint files. He reached a plea agreement. Chief Harmon submitted his resignation before the end of the calendar year. The 9th District was placed under a federal consent decree requiring independent civilian oversight of all use-of-force reviews and mandatory body camera protocols for 5 years. The consent decree was overseen by a federal monitor appointed by the U.S. District Court. The case became a precedent, cited in federal civil rights litigation across 6 states in the 18 months following the verdict, included in DOJ training curricula, referenced in law review articles at 3 law schools. The specific mechanism it established, that a victim's home security footage constituted independent federal evidence sufficient to override a perjured official report, was applied in 4 subsequent cases before the year was out. On a Tuesday evening in August, 6 months after the sentencing, Renee turned her dark blue sedan onto Halcyon Drive in the long, warm light of a summer evening. The ornamental boxwoods needed trimming. She had been meaning to call the landscaper for 2 weeks. The motion sensor light above the front door came on as she reached the bottom porch step. The new deadbolt, installed the morning after the incident by a locksmith who had arrived at 7:30 and had done his job efficiently and without commentary, turned smoothly and completely when she inserted the key. She pushed open the mahogany door. The house received her with its particular silence, the silence of a place carefully chosen and well-maintained and kept through difficulty, and beyond it kept. She set her briefcase on the entryway table. She took off her coat. She stood in the hallway for a moment and let the silence settle around her. She thought briefly about what it had been like to open this door in the weeks immediately after February 6th. The particular quality of attention she had brought to the ordinary action of inserting the key. The way she had for a while been aware of the porch light and the motion sensor and the amber reflection of the streetlights on the wet driveway, with a specificity that was not comfortable. The body's way of encoding and re-encoding a record it cannot afford to lose. That had faded. Not all at once, not in a moment, but gradually. The way the bruise had faded from dark to purple to yellow to the faint trace, and then to nothing visible, though the bone remembered. The porch was a porch again. The door was a door again. The key turning in the lock was just the end of a day. She went to the kitchen, put the kettle on, opened the window above the sink an inch. The August evening was warm, and the air was good, and stood in the kitchen she had designed herself in the house she had earned, and let the quiet be what it was. Outside on Halcyon Drive, somewhere down the block, a child was calling to another child. The ordinary music of a summer neighborhood going about its business. Renee made her tea. She took it to the table. She opened the case file she had brought home, uncapped her pen, and went back to the work that had always been hers, the careful, relentless human work of making the law mean what it was supposed to mean. The door was locked. The house was hers. In the morning, Courtroom 14B would be waiting. Subscribe to our channel for more powerful stories of justice accountability and the people who refused to be erased.